for this particular selection of 2015, the operative rule did not provide us a minimum cutoff in the interview.
Very specifically.
On the contrary, it says that the selection would be made on the basis of the aggregate marks which are obtained in both.
Exactly.
The rule is silent about whether you must also obtain minimum marks in the interview.
I'll just tell you the facts, my lords, which led to this. Not the basic facts only for the necessary information. My lords, this is in respect of appointment to the post of district and sessions judge in Kerala.
Yes.
And we have a rule which covers the selection process, which is called Kerala State Higher Judicial Service Special Rules 1961.
Yes.
The selection process normally in Kerala, this is in respect of selection of 2015. We are concerned with selection of notification of 2015.
Yes.
Prior to 2015, all those selection process were as per the rules, took place as per the rules. And rule says that the selection will be, because there is a written examination and viva voce. Written examination, there are 2 papers, 150 marks each, and viva voce 50 marks, total 350 marks. Written examination, you have to score general candidates 50%, and exemptions are there for the reserved categories, like 40%. Then only you will be considered for the interview. And the selection will be as per the rule 2C Roman 3, my lords. The criteria for selection is the aggregate of written examination and viva voce will be taken together, and that marks will be the selection for the purpose of select list. That is the final. And selection happened in the year 2014, same way. And 4 of my clients here, the petitioners in the first matter, there was no cutoff marks so far as interview was concerned as per the rule. 2014, the petitioners, 4 of the petitioners participated. They scored more than 50% in the interview, but aggregate they lost. So the selection committee said, sorry, you don't have aggregate marks. Though you have 50%, they were out. They were not selected. 2015, this selection, 2015 was the notification. Examination was conducted in the month of March 2016. February 2016, my lords. 17 it happened. Then I'm sorry, I'll correct my dates. The selection process, the examination was conducted in 2016. Thereafter, the results were declared in December 2016. Out of 400 candidates, 40 candidates scored more than 50%, qualified for the interview. So 40 candidates were declared and they were part of the select list, scoring more than 50% in the written examination. They were called for interview in the next year. An interview took place on 16/1/2017 to 24/1/2017. Yes, 17. Thereafter, my lords, after 8 days, administrative committee met. This is how the issue comes, my lords, here. Administrative committee met on 6th of February 2017. Then administrative committee took a decision that in the interview, the person should score more than 50% marks. That is, they fixed a cutoff mark after the interview took place, after the written examination, as well as the interview. The administrative committee met after a few days of the interview, because then took a decision saying that those candidates who have not scored more than 50% of the interview, so interview became the sole criteria. And thereafter, on 21st of March 2017, the full court met and gave approval to the administrative committee's decision. The selection committee was consisting of 5 senior-most judges of the Honorable High Court. And selection committee and administrative committee, the members are one and the same. They conducted the interview.
So your contention basically is that once the process had begun,
yes,
what they did was that after the interviews were held, they decided to have a cutoff of 50% marks in the interview,
true,
which according to you is impermissible.
impermissible. Then, my lords, what happened? That is so the cliche has been used that rules can be, you can change the rules after the game is played. But in fact, my case would be
After the interview. This is actually after the interview.
this is after the interview. After the interview. And I'll just come to the other aspects, my lords. So my case may not be the reference itself may not be recorded for the simple reason that it's a straightaway violation of an existing rule. So whether
What does the rule say, you say?
rule, my lords, 2C3
And which
of Kerala State Higher Judicial Services Special Rules 1961.
2C small 3.
Yes, my lords.
rule 2C? What?
Small 3.
Yes, my lords.
What are the rules called?
My lords, Kerala State Higher Judicial Services Special Rules 1961. My lords, this is a rule under Article 233 read with 309, my lords.
Special rules.
Yes, my lords, special rules.
1960.
Because there is a separate special rule framed under Article 234, but this is a rule framed under Article 233 for the high judicial, subordinate judicial.
Rule contemplated taking only the aggregate marks into account.
Rule contemplates very specifically, and that was the practice also followed by the High Court, that the aggregate of written examination and the viva voce should be taken together, and that is the test.
Result.
Your submission is straightforward, saying that the
So my
administrative decision
Yes, ma'am.
as well as the selection committee's decision as approved by the full court is contrary to the rule.
Contrary to the rules.
So really speaking, the issue of
Doesn't arise,
the change in the rules of the game, etc., doesn't arise
This
because
arise at all,
the
ma'am.
rule itself says that you have to take the aggregate.
So my response.
You can't do by an administrative notification what is contrary to the rules.
And all the judgments so far, supported by Honorable High Court and this side, it very specifically says that Your Lordship have held that even 142 Your Lordship may not go against the specific rules, my lords. And we see mistrust in all those cases, my lords.
So Dinesh, was any attempt made to amend the rules thereafter?
In 2017, later on.
Perhaps-
Later on, they fixed 35%. Rule was amended
For the
for
interview.
the subsequent elections, for the interview.
And for this particular selection of 2015, the
No,
operative rule did not provide us a minimum cutoff
Cut-off
in the
marks.
interview.
Very
On
specifically.
the contrary, it says that the selection would be made on the basis of the aggregate marks which are obtained in both.
Exactly.
Now
True,
tell us
my-
about the litigation. What happened?
Litigation, I'll just. Then we straightaway approached this Honorable Court in 2017. in fact.
32 petition.
Yes, 32 petition, my lords, because there is a contrary. Because
Because-
what really prompted us to approach this Honorable Court directly is that all those challenges were pending in the High Court and happens after 5 years or 6 years. So instead, there is a direct contradiction to the rules, my lords. Straightaway we came
So
to
you
this,
filed a writ petition before the Kerala High Court.
came to this Honorable Court, in this Honorable Court.
32 petition.
32 petition.
Then
32 petition, notice was issued and the arguments took place. And finally, there was, there is a reference order, the Tej Prakash was cited, saying that there is a change of rules after the game is played. In that case, as per the Tej Prakash reference order, this should be referred to along with the Tej Prakash case.
so you cited Tej Prakash.
No, my lords, High
Yeah,
Court
that's
cited
right.
Tej Prakash.
All right.
Then we objected to it, and Tej Prakash is a case where there is no cutoff date at all for the interview. Cutoff marks at all
Now
for
tell
the,
us one thing, just to argue on the other side,
please, madam.
just sort of to elicit your response. The rule says that the selection will be made on the basis of the aggregate marks in the written and the viva.
Viva voce.
The rule is silent about whether you must also obtain minimum marks in the interview.
Lords,
The rule, according to you,
Absolutely.
it tacitly also it tacitly excludes the possibility of fixing minimum marks in the interview.
expressly.
Could it not be argued that look, the rule is silent on what the minimum marks in the interview
In
should be?
in that case, I would like to refer to the rule framed under Article 234, which talks about suitable person can be selected. So there is a question of suitability in 234 rules for the municipal magistrate selections matters.